Having to sell a probate property is actually different from a standard sale since there are court requirements and responsibilities. So today's video will address the probate process, common questions, and 4 things you need to know as an administrator or executor. Hi, I'm Harold Powell, local real estate agent serving Ventura and the surrounding community. So if you want to stay up current on all things real estate for Ventura, I suggest hitting the subscribe, the like, and the bell icon. So let's start off with what is probate. Probate is a legal process through which an administrator or executor representing the estate of the deceased person when someone passes away and their assets are typically transferred to their beneficiaries through the probate process. Now, the assets would include both personal and real property. The executor is the person that will be noted in the will. Now, if a person passes away without a will, then the executor is appointed by the court, and they are generally referred to as the public administrator. Now, since probate is a legal court process, it's best to have a probate attorney involved to make sure all the correct legal documents are filed correctly, as well as advise and guide the executor or administrator. Now, if you need a recommendation for a probate attorney, feel free to reach out and we can recommend a few local probate attorneys in our area. So let's start by addressing the most common asked questions about probate. Number 1, how long does the probate period last? In other words, after a person passes away, how long do you have before you can distribute the deceased estate? Generally, from the time of filing in the court to the approval of liquidating the deceased assets, it takes 9 to 10 months. Now, this is assuming there's a will in place and everything is in order and no legal challenges. I actually provide a link in this description below for the probate timeline breakdown. Now, what will add to that length of time it takes is if the deceased doesn't have a will, then a public administrator will have to be appointed by the court. If the will is contested or if the executor has limited authority, then additional time will be required. So this brings up the 2 types of authority. There is either full authority, which means the executor has the full authorization to handle all the details of probate without the delay from the court. The other is what we call limited authority, which means each step the executor takes must be monitored and approved by the probate court. And as you can imagine, this will slow the process down considerably. The other common question I receive is when someone dies, does the estate have to go through the probate process? The answer is no, provided they have a living or irrevocable trust. Having a trust in place is considerably less expensive than having to go through probate. Speaking of costs, I recommend you watch my video on seller closing costs to familiarize yourself with what costs are involved in the sale of the property. Now, once a person is appointed as the administrator or executor of an estate, there are a number of things and responsibilities and tasks to perform. Here are 4 things to know. Number 1, the administrator or executor of an estate is responsible for managing the deceased person's assets during the probate process. This includes paying any outstanding debts and taxes, as well as distributing the remaining assets to the beneficiaries according to the terms of the will or state law. Number 2, the administrator or executor of an estate will need to locate and inventory the deceased person's assets, including any real estate, personal property, and financial accounts. You may also need to locate and fight any creditors. Number 3, the administrator or executor of an estate will need to file a petition for probate with the appropriate court and provide the court with copies of the will, if there is one, and a list of the deceased person's assets. I actually provide a link to our easy inventory collector in the description below as well. And number 4, as the administrator or executor of an estate, you should be prepared to handle any objections or challenges that may arise during the probate process. This is another good reason to have a probate attorney helping you with the probate process. This may include disputes over the validity of the will or the distribution of assets. Serving as the administrator or executor of an estate is a significant responsibility, and it's important to carefully follow the probate process to ensure that the deceased person's wishes are carried out.